Good morning, Ms. Mary.
Mr. Seeger?
Good morning, Your Honors. May it please the Court, my name is Ken Seeger. I represent Michael O'Loughlin in this matter. Your Honors, the first issue that I would like to address this morning concerns the sufficiency of the evidence, which was the basis for the reversal in the appeals court. This morning, I would also like to address the issue pertaining to refusal testimony, which the appeals court never reached. Your Honors, this case was based entirely on circumstantial evidence. The evidence...
That's not remotely unusual, is it?
I understand that, Your Honor. It's
Okay.
not remotely unusual.
So that's, I mean, that seems to me to be largely irrelevant. I mean, almost all cases are, criminal cases are based on, quote, circumstantial evidence.
I understand that, Your Honor. The Commonwealth can rely entirely on circumstantial evidence.
I have a question about one piece of that evidence. You refer several times to the fact that the defendant had a large amount of money, $500, I think, in his apartment the day after the incident. But was there evidence that he had been paid for his trailer? That's where the $500 presumably came from, I assume. But was there evidence that he had gotten that money, whatever it was for or from, between the time of the murder and the time of the police search of his apartment? Because I thought I recall reading that he was expecting to get the money the day before but didn't. But I may be wrong.
He didn't get it the day before. He was expecting it. That is exactly correct.
So there's a reasonable inference that he got that money after the incident.
He got that money after the time of the offense. That would be the reasonable inference. And there's also
So
an
you can't
inference.
include that on your side, that he had, because I thought I remember reading in your brief, well, he had money in his apartment when they searched it. But it doesn't really matter because he didn't have it at the time of the incident. That's when he supposedly was looking for money for drugs.
I understand that, Your Honor. There's also an inference that he had cashed a check, and that was before the date of the offense.
Yeah, but it may have been used up by then for drugs and beer and stuff.
I understand that, Your Honor.
I thought that the evidence was that the person who bought the trailer gave him the $500 the morning after the incident had occurred, because the place was swarming with police officers. I mean, that was the reason that the person gave for bringing the money over at that point in time.
That is correct, Your Honor. The exact time that the person gave him the money for the trailer, I'm not certain if the record speaks to that. It was certainly after the time of the offense, and during that time period, during the day when the police were searching his apartment and so on. What I would like to point out, Your Honors, is that despite the circumstantial evidence, it was insufficient in the light most favorable to the Commonwealth to prove his presence at the crime scene. And what I would like to point out is that there is no physical evidence that links him to the crime scene. He is excluded from the fingerprint evidence. He is excluded from the footprint evidence. There is evidence, physical evidence of a pillowcase, and that pillowcase was saturated with blood, and there was a...
Was there any evidence that the defendant's hand was the same size as Lieutenant O'Hara's, or could the jury have reasoned that by looking?
Your Honor, there was, that handprint was never measured, and it was never identified as being the defendant's.
Well, that's clear, but didn't Lieutenant O'Hara say something to the effect of the handprint was about the same size as mine, or something like that?
About the same size as the detective's.
Lieutenant's, right.
That's right.
But, and that's why I'm asking, was there any evidence, or could the jury simply have seen, by looking at the defendant's hands during the trial, and I assume Lieutenant O'Hara held up his hand?
I suppose they could have drawn an inference from looking at his hand, but his hand was never, it was never presented to the jury in that. I'm sorry?
It was never put in evidence?
It was never presented to the jury. It was never stand up, show us your hand, and let us see whether it's the same size as the bloody handprints. There was no evidence of that.
Mr.
Was
Seeger,
there-
I'm sorry, go ahead, Justice.
Was there evidence about the baseball bat and whether or not it had been outside for any long period of time, or could they reach any conclusions about that?
Well, the baseball bat is the key piece of evidence here, and that is the alleged weapon. And the record shows that the judge struck testimony that it had been out there for some time. And that should be clear from the record, that he struck that from testimony that it had been there for some period of time. There was testimony that it was outside in the woodsy area near the dumpster, covered with leaves, but there was no evidence regarding how long it had been there. And recall, Your Honor, that when we talk about this baseball bat, the Commonwealth concedes in its brief that it could not conclusively prove that this was the weapon. And in the appeals court decision, the appeals court expresses some very serious reservations whether this, in fact, was the weapon used to commit this assault. And the reason I say that is that, first of all, the only witness to hear this assault was the upstairs neighbor. He was a carpenter. He's the only person who heard it, and he was very distinct in his testimony that he heard the sound of wood striking wood.
But we know that the wood didn't strike wood because this was a person's face being battered. So, I mean, that seems to me to be really quite an assumption.
I'm sorry, Your Honor.
Go ahead.
There was also testimony that the bed rail was struck as well.
One blow. There was one dent on the bed rail, 15 to 20 blows to the head.
That's correct. Well,
and the bed rail was struck apparently with the quilt on top of it, so that, and the bed rail was wood, right? So, I mean, it's kind of hard for someone upstairs to say wood on wood versus aluminum on cloth on wood. I mean, how can that possibly be?
It's just a factor that I'm bringing into this, Your Honor, that he's the only person who heard this, and he testified that it was the sound of wood, and he's a carpenter.
Mr. Seeger, that's correct, and the jury heard that, and that was argued to the jury, and the jury presumably drew its own conclusion. What do you make of the fact, one, that when he told the police and others that he claimed to have been asleep when there was clear evidence that he was making phone calls at the time that he claimed to have been asleep?
Your Honor, the way I would address that question, and this is what the appeals court did in its opinion, looked at the time frame very carefully. Upstairs neighbor calls the police at 1:55 a.m. Police arrive within minutes. Within 10 minutes, they have encountered the defendant, and he tells them that they tell him that they have heard reports of screaming. He responds that he has also heard screaming. It certainly is possible that since the last phone call was made at 1:43, that he had fallen asleep and had woken up to the sounds of screams minutes later.
Right, but we also have this curious that it's November, in the middle of the night, and he's found outside with almost no clothes on. Now, his version that he heard screaming, thought it was animals in the dumpster, and went out to check, does not explain why he's out there half naked. Isn't it more logical that he was out there, police are arriving, and he disposes of bloody clothes somewhere? And that explains, it's a much more plausible explanation of what he is doing outside at that time of night and that time of year with almost no clothes on.
I would suggest, Your Honor, that what is more plausible is his explanation. And if one goes into the time frame, if the police arrive within moments of the 9/11 call, they encounter the defendant. He's the maintenance man. He explains that he has heard screams. That was confirmed, the fact that animals had been getting into the dumpster.
No problem with that. But why would anyone go out to check that without putting clothes on first?
He had been asleep.
It's not exactly an emergency.
He had been asleep. He woke up to the sounds of screams. He's the maintenance man. It's his job. He runs outside. Now, what I would like to explain about the time frame is that the police encounter him within moments. It's all within 10 minutes. According to the Commonwealth's theory, he has already committed this ferocious assault, 20 blows at least. He has returned, cleaned off the bat, discarded the bat, covered it with leaves. Remember, there's a bloody handprint. There's a pillowcase saturated with blood. The police did not see any blood on him. So he would be cleaning this off. And this is all within moments. And when the police, and the appeals court points this out, when the police encounter him, he's not even out of breath. And this is within 10 minutes. So this is a factor that the appeals court looked at very closely and found that it simply wasn't plausible. And
But is that, I mean, that's a great argument to make to a jury, but isn't the test here, taking the evidence in its light most favorable to the Commonwealth, could the case have gone to the jury? And it seems to me that you can't approach it from the way you're approaching it.
well, many cases are affirmed based on circumstantial evidence. The Commonwealth has cited many of those cases. In my reply brief, I tried to distinguish those cases. For example, Leo, where the defendant is walking down the driveway. He doesn't live anywhere near the scene of the crime. Courts simply have to look at all the circumstantial evidence and just
But
scrutinize
here, the
it.
fact that the defendant lives near the scene of the crime adds to the Commonwealth, is in the Commonwealth's favor. He has plenty of opportunity. He lives near there, and he has the key. He lives, in fact, very close.
There's no question about it, and as the appeals court pointed out, there is evidence of means, of opportunity, there's evidence of motive.
Of motive, there's plenty of evidence, it seems to me.
But the combination of these factors simply don't add up. It's inference piled upon inference. And what I would like to point out about
Can
motive...
I ask you a question? At the end of the opinion, the appeals court talks about the third-party culprit evidence involving this woman's, was it husband or boyfriend? I can't
Former
remember.
husband.
Former husband.
Or husband.
And they say that this, if they're, this is kind of a close case in so many words, but this third-party culprit stuff sort of ices it for the defendant. Conceptually, how does that play in? You're supposed to take the evidence most favorable to the Commonwealth, which would be the evidence introduced primarily in the Commonwealth's case. So where do they come off? I assume this evidence was presented in the defense case, or did it come out by cross-examination of Commonwealth witnesses?
It came out through the Commonwealth's case on direct and through cross, and it was further developed in the defendant's case.
So is it okay to consider that on a required finding? Or does it come up, does it analytically come up when they renew the motion at the end of all the evidence?
Well, my reading of the appeals court decision...
Because the standard there is only, quote, if the Commonwealth's evidence has deteriorated, and that's fairly strictly construed and wouldn't encompass third-party culprit evidence. So is there what I call a logical gap in the appeals court reasoning here?
I would suggest not, Your Honor. And as I read the appeals court opinion, they're not evaluating the defendant's evidence and ruling this has now caused the Commonwealth's case to deteriorate to the point where the required finding should have been allowed.
Yeah,
They're
but
not reviewing it in that manner.
But no, they don't say that. But don't they throw in something at the end? I don't have the opinion in front of me that says, well, by the way, there is this third-party culprit stuff, and there's a big, long footnote describing it, what it is, about the ex-husband. And then they sort of say, this adds to our conclusion, supports our conclusion.
They're not examining the evidence on the deterioration standard of review. They're not looking at it that way. Rather, they're looking at all the evidence and saying, well, this third-party evidence detracts from the Commonwealth's case in chief.
And that's all right to do?
They cited the case Commonwealth versus Torres, which apparently had been reviewed before, and apparently they felt that...
So we'll go look at Torres, and maybe the answer is there.
I think Torres answered the question the other way. They found that the third-party evidence didn't detract, but the court reviewed it.
But Torres was a little unusual because in Torres, as I recall, there was that was a child case, and there was the mother and the father, or the mother and a boyfriend, and they both accused each other. So there was no question in that case. I mean, this wasn't some hypothetical unknown person.
The appeals court is simply looking at the circumstantial evidence. They're scrutinizing it very closely, and they're ruling that it simply doesn't add up to meet that Lattimore standard. Your Honor, if I may, unless there are questions about the evidence, I would like to continue and move on to the issue concerning the refusal testimony.
You have a few seconds.
I have a few seconds. Even if this court finds that the evidence does reach that Lattimore standard, you've got very clear refusal testimony. And you have a line of cases, Leiden, Conkey 2, all of which have considered refusal evidence. Leiden involves swabbing. In this case, police asked the defendant if his consent included swabbings. He said it did not. It's very clear, very express, unequivocal. It's entered as consciousness of guilt, and this is precisely why it should be excluded, especially in the case where the circumstantial evidence is not overwhelming. Unless there are further questions, Your Honor, I see my time is up.
Thank you, Mr. Seeger.
Thank you.
Mr. Capers?
Good morning, Your Honors. May it please the Court. For the record, I'm Berkshire District Attorney David Caples, appearing on behalf of the Commonwealth, and I was trial counsel. I would first state to the Court that the appeals court not only placed undue weight upon the arguable defense evidence presented on behalf of the defendant, particularly the third-party culprit evidence, but more importantly, misapprehended crucial evidence relating to the scene and the immediate aftermath, which set the tone for its decision.
Mr. Caples, I haven't read the transcript of the trial, but based on the appeals court decision, which I've read with care, and your briefs, both briefs, it seems to me that it seems to me anyway, that there is enough evidence to get to the jury here. But I have concerns about three specific areas, should we conclude that there is enough evidence to get to the jury, and I'd ask you to address those three areas. One is the handwritten note. Why was that excluded? That's number one. And why couldn't the jury simply have compared the note, another note that the woman had written with the handwriting on the note that was excluded? Second, the refusal evidence. Is there a way to redact that evidence to allow in evidence the fact that he wiped away the stain without putting in his refusal evidence? And third, the closing argument. Was there evidence that the defendant's hand was about the same size as Lieutenant O'Hara's? And was there any evidence that the defendant had actually used the pillow? I suppose the third is the least important at this point, but certainly the first two I'd like you to address.
First, as to the note. The note was excluded by the trial judge, Judge Curley, not on the basis of identification by handwriting, because it was further argued before it was definitively kept out. It was kept out on the basis that it was not probative. Even if a jury could determine, looking at other writings that the victim, Mrs. Katowski, had said, in fact, were hers, even though she didn't remember writing them, and compared it and said this was the note. The way the note was written, it would be pure speculation to state what the note meant. He's going to kill. He's threatened. There was no evidence. She denied writing it.
Right.
She denied having any knowledge of it. And it would be purely speculative for any juror to look at that and say, who was the voice in the message? Who were they talking about, and what were they talking about? And that's why Judge Curley excluded it.
But wasn't there evidence that this woman, the victim, had never really spoken with this defendant? I mean, that she knew of. She didn't know him.
There was the lone evidence was that on one occasion the defendant had surprised her, and to his amusement, he thought he had scared her, passing by her one time when she appeared to ignore him by saying, oh, are you happy with your window?
Right.
And that was the only time that they had any conversation.
Okay, given the lack of communication between them, except for that one statement, which I remember, the inference from the note would be that it wasn't the defendant who was the utterer of the threat, because she never had any communication with him wherein he would be making a threat.
It might not be unfair to say that it would not refer to the defendant.
Right.
But what about the rest of the world? It is certainly not clear enough to indicate who specifically that refers to.
But what difference does that make? The defendant doesn't have to. I mean, I assume in part the defendant was pointing a finger at the estranged husband.
Yes.
But the defendant could also be pointing to say there may be other people who hated her.
But that's the point, and you can't say who it was.
But that doesn't matter. But that doesn't matter, Mr. Capers, because the who it was is not on trial. The defendant is saying, I need to have the opportunity to say there are other people unnamed to me, I don't know them. I mean, why is that not probative?
Because it would have to place relevance to otherwise detract from the evidence. If there had been evidence presented, such as there was, that David Katowski was, in fact, upset with the situation that his wife had separated, moved out of the apartment, and had a new boyfriend.
But
that was there, but that didn't.
Mr. Capers, let's assume that there's a note in the apartment of a victim, right?
Yes.
And the victim dies. Not this case. The victim dies. But there's some evidence that the victim didn't like the note. No idea who wrote it, but it says, "I'm going to kill you." And there's clear evidence that the defendant did not like the note. In other words, you get the experts and that, and the defendant says, look, somebody else could
That
have...
would be probative. I would agree with the court, but that is not the situation here.
Because?
What's the difference?
Because the only way that the defendant can offer this is coming in is that it was written by the victim. She denies it. And if
No.
it was, in
no.
looking at the note, one
But the
can't
jury
say, what
could-
does it mean?
But the jury could have analyzed the handwriting. She denies it, but she's had some memory fade.
Even
she
if
hadn't
the
had
jury
memory fade.
concluded it was hers,
Okay.
it would be speculation to say what the note meant.
Well, somebody was threatening her is what the note meant, would be the reason.
I think that's speculation to say that.
What were the words of the note?
It's something to the effect of
Threat to kill him if seen in public.
threat to kill him seen in public. Is she referring to one of her daughters talking about somebody else who said something? Is she referring to her husband having said something about somebody else? Is she talking in her own voice? This is the problem with it. You cannot place the voice, the context, or the content.
What about...
It's pure speculation.
What about the other notes? I mean, I'm simply looking at the record, which I take...
They don't aid it. The only aid that they may have is on the fact of the handwriting. And I say that was not the actual basis for exclusion by the trial judge. If I may talk about the refusal evidence, the Commonwealth introduced evidence that after the discovery of the body, the police in their course of their investigation that morning and into the afternoon had started to focus on the potentiality of the defendant. He became a suspect. They asked and were granted consent to search his apartment. While they were in there, they saw what appeared to be, what looked by appearance to be possibly blood on a wall structure. Asked if they could do testing on it. The defendant then said, testing, I didn't agree to that. Asked them to leave. In the few minutes while they were outside, the defendant went out and wiped it away, went back out and talked with the officers, invited them back in.
Well, they said we're coming in to secure the apartment because we're getting a search warrant. And he said, don't get a search warrant. That's not necessary.
Right.
Signed a consent form, allowed them then to swab.
They come back in, see it's gone. He
says it's gone.
tells them,
He
I wiped it off.
They still test it.
The concern normally with refusal evidence is that it impermissibly allows a jury to infer, in the lack of other evidence, consciousness of guilt by the refusal. But here, you have the consciousness of guilt evidence in that, in fact, he did wipe it away. The jury's not speculating.
But the jury were told.
Yes. But from the defendant's own description, that in fact...
The jury needs to know, it seems to me, that the defendant's attention had been drawn to this blood stain and that he knew the police were interested in it.
It explains all of the circumstances.
Right, but Justice Counselor's question, was there a way of redacting the refusal part out of that and still somehow letting the jury know that the defendant was on notice that the police wanted to swab that stain?
Well, when we have a circumstantial case, a wholly circumstantial case, in which the quality of the investigation and the thoroughness of the investigation becomes so important because you're always considering, was there the other possibility? Is there other evidence? The fact of having to explain that the police left at the request of the defendant, but came back when the defendant allowed them back in, didn't allow the jury to then wonder whether or not the police were inattentive. They lost their attention. He wiped it off. How good are these guys that they allow evidence that they, in fact, had focused on to then be lost to them, even if the defendant did it?
It's something like when police are interrogating somebody, and in mid-interrogation, he exercises his right to a lawyer, they're at least allowed to to show why the, to introduce
Why it
that,
stopped.
To show why it
Or
stopped.
if it stopped and started again,
Yeah.
then in fact they were being careful, they were affording the defendant his rights, they were being cordial with him, and then in fact, you know, it's in that case that it resulted that they then had further conversation. Here it explained all the circumstances. But the important thing is, this was not a matter of impermissible inference. There was the direct evidence that, in fact, the defendant had wiped it away because, in fact, he was concerned about it, and it either makes it inconsequential or, in fact, removes the whole problem entirely. Finally, as to the closing argument, there was...
Let me ask you, Mr. Capers, what is the relevance of the fact that the defendant revoked his consent? It can't be just to show...
It explains why the police left and how it was
Is that really
trained police
necessary?
officers in the course of an investigation who have focused on a piece of evidence and want to collect it, quote, allow it to then be wiped away by a defendant. It explains that, so that it isn't their inattention, it's because they were following what they should be doing. The defendant had the constitutional right to say, please leave, they did, and they came back.
If there was no evidence if there was no evidence that the defendant had wiped it away, okay, just assume that there's no evidence the defendant had wiped it away. So, that, I mean, the defendant didn't say anything, and the police officer testifies that when I was in the apartment, you know, and the claim is absolutely no evidence of blood anywhere by the defendant, okay? And the police officer says, when I was in the apartment, I saw blood. When I came back, I didn't see blood. In those circumstances, perhaps. But here you have a defendant saying, I saw blood.
What he thought was blood.
What he thought was blood. And he's a detective, and he's seen lots of crime scenes. And I went to obtain a search warrant. Right? That can come in.
Yes.
Can't it? And when I came back, the blood had disappeared, and the defendant said, or the marker disappeared, I wiped it away. That is pretty compelling testimony. In fact, it says, I was very careful. As soon as I saw something, I went to get a search warrant to test it.
Yes.
No refusal. Just, that's what I did. And the prosecutor argues this is the most careful of all police officers. He sees it. He goes to get a search warrant so he can test it. By the time he comes back again, the defendant admits, ladies and gentlemen, that he
He not only says that he wiped it away, but he also says in other comments that he believed it was blood.
The defendant?
Yes.
Yes, so you don't need
And
to
so it
refuse.
isn't a matter of an impermissible inference,
So you
direct
don't-
evidence of why he did it.
Yes, but you don't need the refusal testimony. You can redact it.
Well, again, I say that it fully explains all of the circumstances which are important here,
Yeah.
but also does not allow the jury to otherwise think that the police were inattentive.
I mean, it's still, what's missing from the chief's hypothetical is that there was nothing in there that had brought the defendant's own attention to, we are interested in this spot of blood.
Well,
Well,
the officer could have testified that we went in, we saw the blood, and then we immediately decided it was necessary to get a warrant. We went out.
Right.
While we were gone, then
But-
we come back, there's no blood. Defendant says, I wiped it away because they thought it was blood, or whatever.
But the problem is, as Justice Osman has pointed out, you don't get across to the jury of why he did that, because he saw, now he sees,
Somehow-
they found something that I didn't realize at first was there.
But the
And I'm
officer,
concerned.
but couldn't the officer testify? I was in there, I saw the blood,
I
defendant was
asked him
present.
what it was.
Well, but it's probative that, in fact, the defendant was aware that they were interested in, they were going to collect it,
No.
and we're going to test it.
Police officer says, I asked him what it was.
And again, it's consciousness of guilt. As it turned out, it wasn't the victim's blood. The point was, what did the defendant think in the day following it? Why did he act that way?
But you can get that in without getting, you don't need that he
The
consented
Commonwealth
and then he
suggests you don't get
refused.
all of it in what is necessary to prove that. And again, what is improper about it is overcome by what is the improper potential inference is wholly overcome by what is the direct evidence of what in fact happened and what was the defendant's intent.
I
Mr.
suppose-
Caplis, one of the things that concern me here is this is a defendant who, leaving aside the brutal attack on the woman, was clearly engaged in illegal activities, correct?
Yes, Your Honor.
So consciousness of guilt, if you're confronted by police officers, I mean, the attack aside, he's guilty. I mean, he knows he's guilty. He's dealing in drugs. He's using drugs.
Well, there's no indication he was dealing drugs, but using drugs. In fact, the defendant, during the course of the search, spoke to the officers about them finding cocaine use paraphernalia in the apartment.
But he said that after...
He admitted it to him because he said, look, I'm concerned you're going to find it. What are you going to do? They said, look, if we find it, we're going to have to get it out of here. He asked if he could keep it. They said, we got to get it out of here because we know you got kids. But no, we're not going to charge you with it. And they didn't.
But
So that he has shown that that's not his concern.
Well, that was his concern. That was a concern, though.
It was a concern.
When he asked the police officers to come back in without a warrant, he said, look, but here's the problem.
But he
Here's why I'm
expressed it.
concerned. Yeah.
I suppose you could argue that the refusal evidence, if it were error to allow it in, it was harmless error
That's your
on the
argument.
basis that
That's what I'm
since the
arguing.
defendant said anyway, I erased it, I rubbed it off because I knew it was blood, therefore that makes the
Well, it's-
refusal evidence
He
just harmless.
objected to it, right?
Yes.
So you have to say it was
Yes.
not prejudicial beyond a reasonable doubt because the consciousness of guilt that
Yes.
clearly was permissible evidence is so overwhelming that this really goes by the board.
I feel the need to just mention it. The appeals court talked about this had to be a bloody scene, he had to be bloody leading. The actual evidence was, it was found as a bloody scene from the blood that had oozed from her and had been smeared by the victim around solely in that bedroom. There was almost no spatter anywhere in that bedroom, and most particularly outside the bedroom. You come into the apartment, it's the one on the right, and the bathroom is attached to it inside. Outside in that hallway, on the carpeting, on the walls, on the door jambs, and particularly on the door that you have to go out to get out. No blood, visible or latent. Whoever
Including
was
foot-
the attacker did not get himself covered in blood
Mr.
such
Case-
that he left it leaving the apartment.
Excuse me, Mr. Capers, including footprints.
Including footprints,
So that even if
footprints, fingerprints, or blood, even occult blood that was not visible to anybody, that was
understand
left
that.
on any surface outside.
Well, but I
I
thought the
take
evidence
it
was
that-
the pillow was very bloody, indeed so bloody that there was a handprint on it.
Right.
Which
One could then easily wipe off and not be detected as any one of the bloody items that were left there.
Is it that the body was bloody, but there wasn't much other blood at the scene? Is that it?
There was, but if looked at carefully, she lay there for a number of hours following the attack. The blood oozed out of her in her struggle to try to get to the bathroom. The blood that was up on the walls was smeared blood from her hands, which she had brought to her head, were also themselves highly injured from fending off the attack. But that's what the blood was. Spatter from the attack itself was almost non-existent.
Well,
In
I
looking
take
at the
it-
photos, and particularly the video, which looked 360 degrees around that room and focused particularly above the area of the floor, showed practically
I
nothing.
take it the thrust of the attack was to her head,
Yes,
correct?
yes.
And she was lying down.
There was evidence suggesting that she had been in bed when first attacked,
Okay.
but that she had both numerous bones in both hands were broken, that she had fended off the attack, but ultimately ended up on the floor. By inference, there had to be some attack on the floor because some of the missed blows struck that headboard covered by the quilt, causing the impression of the quilt to be embedded into the wooden sideboard of the bed, and that's where she was found lying on the ground.
Thank you, Mr. Capers.
Thank you.